Hey, this is Daniel O'Connor of the Bryant & O'Connor Law Firm. Today I'm talking about the rights of in-laws to your estate. I have a number of people and have had a number of people over the years express concern about an in-law or an in-law's children that aren't their grandchildren possibly getting their family farm or property or that kind of thing. And but the reality is, I want to clear one thing up, an in-law will never be your heir. So if you die and your child has predeceased you, if you don't have a will, your child's children would receive your child's part, not your deceased child's widow. So I think that's a relief for some people. Also, generally speaking, if you use per stirpes language, really, unless you spell it out that you want a spouse, an in-law, to receive your property, even if you leave property to a child in a will, their spouse, if that child predeceased you, their widow will not take their place. So an in-law, very rarely, unless you spell it out, that's what you want in your will or trust, an in-law is generally not going to become your beneficiary. But let me tell you how it does happen that an in-law becomes the actual benefactor of your property. Let's say, for example, you leave, and I see this all the time, you leave property to your child, and your child, before they make their own estate plan or some other provision, your child dies after you. So after you die, your child was entitled to whatever it was they were going to receive out of your estate. This is generally speaking. There are protections you can put in your documents if you spell it out against this, but generally speaking, your child was entitled to whatever it was that you left them at the date of your death. But then they die after you. Well, guess who gets the property or their share of the property after that? It would be their estate or whoever they've left the property to. Or if they didn't have a will or trust or anything, then it would go to their heirs at law under the laws of intestacy, which almost always includes their spouse. And that's how an in-law can gain an interest in property. If you don't want that result, you want to ensure that your child's children benefit, you pretty much have to use a trust. And trusts are used for hundreds of different things, but if you leave property to a child and you want your child to have control over it, there is nothing you can do to stop an in-law from getting it out of your child's estate. Nothing you personally can do at all if you make an outright gift to your child. Outright gifts expose gifts to their spouses, to their creditors, to anything like that. And so if you don't want your child to have that kind of control and leave open the possibility that they could sell the property, that they could give it to someone you don't want, someone you don't even know, you've got to leave it to them in a trust that protects the property. So some people, it's important enough to do that, some people it's not. So that's just something that you will have to decide. But back to the point, an in-law doesn't have any right in your estate. They may have a right, and likely will have a right, in the estate of one of your heirs. So that's where in-laws come in.